Hello, everyone. Welcome to Management 413 Employment Law here at the UAB Collat School of Business. In this video, we will be covering hiring and promotion decisions using Chapter 7 of our textbook, Employment Law for Human Resource Practice. Here's what the outline is for the video. What are the criteria for hiring and promotion, interviews, and offering and accepting employment, and what are the legal risks in all of these? Looking first at what criteria we use to hire and promote people. Remember that it is disparate treatment discrimination to have a policy that expressly says that you will hire on the basis of a particular protected class. The only way that that might be able to be excused would be if you had a bona fide occupational qualification defense. But remember, a, a BFOQ can never be argued in the case of race. You can never, ever say that someone must be hired on the basis of race. So what does it take for there to be a BFOQ? The employer has to show that only people within the specific protected class can do the job and that that job is integral to the operation of the business. It has worked for employers to argue that only females can be dressing room attendants at a retailer where there are women customers. It has not worked where a corporation with Latin American operations tried to argue that being a male was a BFOQ because males did better in a Latin American culture. That was not successful. Here are some guidelines for when it might be possible to say that you have a bona fide occupational qualification based on a protected class, that's the only way that your product can be authentic. Such as an actor in a movie role, but I'd like you to remember who played the part of the mother in the movie Hairspray. Sometimes you might say that a BFOQ is justified for public safety reasons, but that did not work in the case you can see here, Briner versus Nevada Department of Corrections, when the prison tried to argue that only female guards should be hired for a female prison. Sometimes you might argue that you need a BFOQ for privacy. That might be the case in the dressing room situation. It also might be the case for a nurse on duty where victims of sexual assault are treated. Two of you will have this simulation. The male who wanted to be a counselor at a weight loss center where 95% of the customers were women. Sometimes employers try to fashion the criteria for promotion and hiring in a neutral way, but then go about applying it on the basis of a protected class, such as an employer refusing to hire women with children under 5, but then hiring men who had children under 5. They were not able to establish that this was a bona fide occupational qualification. Sometimes these cases are called sex plus cases. Another criteria occasionally used would be weight and appearance. I think we all know that physical appearance has a pervasive effect on employment outcomes. People who are judged to be better looking often do better in their professional careers. Discrimination is common based on weight, but I think it's pretty clear that men are given more slack than women. One state, Michigan, and some cities, including San Francisco and Washington, D.C., make weight a protected class. Under the Americans with Disabilities Act, a worker can use weight as a disability, but only if he or she is medically obese. Sometimes sex stereotyping becomes the criteria for hiring and promotion, and that is not very advisable. Look at the example on page 235 of the textbook where Burlington Coat Factory required female clerks to wear maternal-looking smocks while male clerks only had to wear business attire. This was found to be illegal discrimination based on gender on the basis of sexual stereotype. Here's another interesting sexual stereotype case that went to the United States Supreme Court a few years ago. This woman was up for promotion to be a partner at one of the largest accounting firms in the world, Price Waterhouse. She was turned down for that because she did not act or dress in a feminine enough manner, and the Supreme Court had to decide whether or not that violated Title VII's prohibition on gender discrimination. The court found that it did violate Title VII. Uh, Look at a similar case involving a hotel clerk, Lewis versus Heartland Inns of America. Here's a case involving gender identity. A firefighter, he started his career as male and transitioned to female, began to adopt a more feminine appearance, and he was harassed and eventually quit. He sued the fire department, sued the city of Salem, Ohio, and he was successful in arguing that he had been discriminated against on the basis of gender. Sometimes there can be discrimination against caregivers. Employers will use as a criteria for hiring and promotion whether or not the employee has caregiving obligations outside of work. This is not a protected class characteristic, but nonetheless, it can give rise to discrimination claims. We have a simulation here. Chapter 7, question 3 involves a woman with 2 young children who was fired because she did not want to have to attend out of town conferences. Is that illegal discrimination? Many times you cannot find an objective criteria for a hiring or promotion decision, and there are subjective criteria at work. A very common or increasingly common term today would be that people need soft skills in addition to hard skills. Sometimes soft skills gets expressed as whether or not someone would be a good fit, and that can be very problematic if it's really a pretext for some sort of illegal discrimination. Look at the example of promotion and hiring for pilot positions in the airline industry. A lot of subjective criteria were at work here, apparently, because the pass rate for females was 27.9%, but the pass rate for males was over 46%. Interviews. Just as subjectivity in hiring and promotion can be dangerous, it can be dangerous in the interview process, can lead to charges of illegal discrimination. I think it is a very good idea to write down in advance what your interview questions are going to be. If you're going to have multiple people interviewed, use the same questions with everyone. Make sure that you can articulate some specific objective grounds if you think that someone did poorly on an interview. Simply saying, well, I don't think that he or she would be a good fit, could be argued to be a pretext for illegal discrimination. Look at Hamilton versus Geithner. Geithner was the former U.S. Secretary of the Treasury, and Hamilton argued that the comments he had received about a bad interview were really just a pretext for discrimination based on his race. The process of offering and accepting employment can create legal risks. One way to manage those risks is to write it down. Remember what we've said about documentation. Have an offer letter that includes exactly what the salary will be. If it's an employment at will relationship, which it probably is, state that in the letter and make reference to any handbook that you might have. Sometimes offers get withdrawn and employees sue. That usually is not going to be grounds for any successful legal action by the person who had the offer and then had it taken away, unless the employer perhaps knew that the offer was going to be taken away when the employer made the offer. Sometimes you might be able to argue if you relied to your detriment on an offer that it would be unfair for the offer to be taken away, but I don't think that would happen very often. Here's one case, however, where it did happen. Gorham versus Benson Optical. You can see the facts there on page 250 of the textbook, and those type of cases are called promissory estoppel cases, and you can see the elements of one of those claims here. Promotions within the business world are commonplace, but as we said in the very beginning of the course, there is pretty clearly a glass ceiling for some people, particularly females. It is pretty clear that men get promoted more easily than females do. There are a lot of complicated reasons for that. Law firms and accounting firms start out in the first years with equal numbers of men and women, but by the time the most important promotions take place to partner, for example, far more men actually get those promotions than women. The only way, there's no one clear-cut way to do it, but the only ways that people know of to ensure that promotions are done in a fair, non-discriminatory way is to post them and make sure everyone knows about them. Make sure that your training and development is available for everyone. Try not to rely on subjective criteria. Here is a mechanism that UAB uses for advertising both internally and externally all of its job opportunities, so that if you worked at UAB and thought you could perhaps get promoted into one of these, you would know about it. The Department of Labor actually does recognize a glass ceiling as a reality. You can see here what the definition is. One example of the type of process that will sometimes lead to glass ceilings are in large organizations with international assignments. When you get to the highest reaches of these very large multinational companies, often one of the final criteria is whether or not you've had international experience. And it's pretty clear that men usually get the international postings for a variety of reasons, maybe because the women don't want to be traveling or moving abroad when they are the primary caretakers of their children. But in any event, the glass ceilings are a genuine issue, and one that a lot more study is going to have to go into in order for us to overcome that. That's it for this set of slides. In our next set of slides, we're going to go beyond the hiring process, and we're going to be looking at affirmative